You're going to want to begin with some background questions. Remember, I told you your witness is probably going to be terrified sitting there on the stand? Start out with some easy softball background questions. Are you currently employed? Where do you work? Things like that. And get those just to settle the person down. They're maybe not relevant, to be honest with you, but the attorney on the other side is not like, they know you're just asking some general background questions and they're harmless. And they know if the first thing that they do as soon as you go, are you currently employed? Objection, relevance, they just look like a jerk. They're not going to do it. Probably. I can't guarantee it. But you start with a few background questions to just put the witness at ease. You're going to then move on to the meat of your questions. You're going to want to lay down a foundation. And this means that for a witness, you want to establish that the witness has personal knowledge of what they're testifying to. If they're an expert witness, you're going to need to establish their professional credentials and ask that they be received as an expert and that they've reviewed the evidence, other evidence in the case that's already been deemed admitted. But whatever it is, you're generally going to want to show that most witnesses have personal knowledge of whatever facts it is that they're testifying about. And then you're going to want to use that witness as well if there's any evidence that you want them to bring in. Photographs, documents, whatever it is, you're going to want to use that witness to authenticate the evidence so that you can then have the court receive it as evidence. Your checklist for getting evidence received by the court. But when you have an exhibit and you want it to be brought into evidence, your first step, you make sure opposing counsel has seen it. If it's already been disclosed, they already have copies of it, great. But generally, bring copies for yourself, the witness, the judge, and the clerk. And you're going to make sure that opposing counsel has a copy of it. One of the things in pretrial that you're going to want to ask is, whether or not the judge wants your evidence to be pre-marked as exhibits. In which case you generally put a little gummy label on it that says, defense or plaintiff exhibit A, exhibit B, C, so on. Or if you want it to be, or if they want you to present it to the clerk to be marked as evidence for identification. And if they say pre-mark it, a lot of judges like that because it's faster. If you have your own labels on everything and if you have your own labels on everything and you don't have to send everything to the clerk to put a label on it and mark it beforehand. But if they want to do it the old-fashioned way, that's fine too, in which case you would, Your Honor, I would like to ask that the clerk mark this document as Defendant's Exhibit A. And then it would be presented to the clerk would mark it as Defendant's Exhibit A, and it would be added to the index. You'd add it to your index, and then you take it back. It's a pain, and it's slow, but you may have to do that. Yes?
So doesn't the defendant and the plaintiff have different identifiers? Doesn't the defendant have the letters and the plaintiff have the numbers?
There's wide discretion within each court. Talk to the court specifically in pretrial to make sure there's agreement. But at the very least, even if they're both numbers or both letters, remember, one is defense and one is plaintiff's. Then you're going to, ask to show what has been marked as, marked for identification as exhibit whatever to the witness. And then you're going to elicit testimony authenticating that. If it's a document, is the person who wrote it? Is the person a custodian of records who's identifying a business record over which they have knowledge of the process in which it's kept and created? If it's a photograph, does it fairly and accurately depict what's in the photograph? Whatever testimony is needed to authenticate it, you're going to get out of that witness. And then you're going to ask the court to receive it into evidence. And if it's authenticated and there's no other objection as to why it should be kept out, it's then received into evidence. And the importance of receiving it into evidence is that anything that's received into evidence, if the judge or the jury they get to see it in deliberations. If you go through all of the effort to authenticate something and don't have it received into evidence, it's kind of a wasted opportunity if you want it to go back there with the jury. So always be sure to do that. And I've seen that mistake. I've made that mistake. You know, to authenticate something and then forget to have it received into evidence. Few tips. You know, when you do your questioning, keep an outline and just check things off as you go. If you get mixed around, if the witness goes off tangent and you need to get back, that's going to be your map to get you back on topic and to make sure that you got everything. If you have any really, really super complicated questions, those are the ones you want written out verbatim. You're going to probably be reading them. Try not to look like you're reading them, but it may be necessary. And be sure that you've practiced, and your witnesses should feel a little more freer to expand on their answers when talking to you. You know, but you should be practiced so they know how far not to go. By the way, keep it simple. You don't want to lose your witness. You don't want to lose the judge. You don't want to lose the jury. Don't ask anything that's compound. Ask multiple questions. Keep it easy to understand. I'm going to go ahead and skip along because I already said that you have to establish that your witnesses have personal knowledge. Next thing you need to do, anytime you ask a question, anything you ask needs to be relevant. Relevant means that it tends to prove or disprove something that you or the other side needs to prove or disprove to win their case, or goes to the credibility of a witness. As a general rule, if it's relevant, it's going to be admissible, but there are some exceptions about that. And the practice guides really go into a great bit of detail about that. Third thing I'm going to talk about really briefly that is hearsay. You hear that word all the time, but it probably doesn't mean what you think it does. In legalese, hearsay is where you have a witness testify as to a statement made by another person who's not the witness, where you're trying to have that entered into evidence to prove what the facts that the other person said. It's basically a rule that was created for reliability. If somebody said something, you should, or if somebody said something, you should have that witness there to say it. Not somebody else saying what that person had said. Now, with that instead, said, there are going to be a lot of exceptions to this. Business records is one of the common ones. The custodian of records didn't make the business records, but is familiar with the way that they're created, and they're regularly kept in the course of business, so that deals with the issue of authenticity. You're also going to have statements of a party opponent. If the other side says something, that's going to be against their interests, generally you can have another witness attest to it. And the reason that's reliable is because the other side's right there and can testify to try to set the record straight if they didn't. There are also going to be situations where something might sound like hearsay or it's not. Let's say that you have a witness who is testifying as to what somebody said at the scene of, let's say you have a witness who's testifying as to what the victim said at the scene of the accident. It's like, and did you hear when you arrived at the scene of the accident, did you hear Mr. Smith say anything? Yes, he said that the defendant is a horrible person. Objection, hearsay. Your Honor, we're not attempting to enter it to show that the defendant is a horrible person. The reason this is relevant is because it proves that the victim was alive at the time that the witness arrived. You can enter it, so even if something is hearsay for one purpose, it might not be hearsay for another. Questioning yourself. Yeah, it's odd. There's no way around that. Most of the time, the court will relax the procedure, especially if you're not in a jury trial, and more or less allow you to tell your story. The other side may oppose this, and the reason is because it's very hard to object if a witness is just allowed to freely tell their story. If there are no questions to object to, you can't issue valid objections. Be prepared to fully question yourself if absolutely possible and hope that the process is relaxed. If you have to question yourself, your process is typically going to be wearing two hats, yourself as attorney, yourself as a witness. You would ask the question, pause, wait for the objection, and then provide the answer. And just repeat this again and again until your questioning is done. The other possibility is if you can work out with the court and the other party to possibly have another person read you questions. However, if you need to rephrase anything, that breaks down very quickly. Hopefully the rules will be a little bit relaxed for you.
With regards to objections, do you have to state the reason for the objection, like hearsay or relevance or whatever? Do you have to give a cause?
Technically, yes, because if you are objecting, you specify the reason for the objection so the judge can rule on it and also preserves it for the record so that the reviewing body knows what you objected to and why and can determine whether or not the decision was correct. In some instances, you might just say objection, and before you even have a chance to do anything, the judge is going to jump in. Let's say that it's clearly irrelevant. Were you wearing purple underwear at the time of the act? Objection, and at that point, the judge is probably going to jump to conclusion and say you're objecting on the grounds of relevance, and you're not even going to get there. It depends on the judge, but always be prepared to state the reason.
Like, subscribe, and click the notification bell for new videos. To learn more about my legal services, click the links in the description section of this YouTube video or on one of the video links on your screen. Thanks for watching. Bye for now.